We're on. I wish to welcome everyone to this meeting of the Health, Occupations, and Long-Term Care Subcommittee. We have five bills on our agenda for today, and this meeting is being live streamed. It is being recorded, and we will begin with House Bill 172. Council. Health, Occupations, Licensed Athletic Trainers, Dry Needling Approval.
This bill authorizes a licensed athletic trainer to perform dry needling as a specialized task if the athletic trainer is approved by the Maryland Board of Physicians. The board must issue an approval to perform dry needling to a licensed athletic trainer who meets the bill's requirements. I circulated the third reader version of the cross-file in this bill to reflect the amendments that the sponsor would like this committee to adopt. The amendments strike an erroneous cross-reference, alter the instruction requirements under the bill to require the hands-on instruction to be completed under the guidance rather than supervision of a licensed healthcare practitioner, and specifies that the instructor be approved to perform dry needling, and clarifies that the assessment must be performed by the course instructor. And so these are the amendments that the Senate cross-file passed the Senate with.
And what was the vote in the Senate? I believe it was 44-1. Council, when this bill passed the Senate, it was 44-1.
Yes, 44-1. Sorry.
Thank you. Is there discussion on this bill and on the amendments or on the amendments?
Move the amendments.
So moved. Seconded.
Second.
Okay. The amendments, or any objection to the amendments? Hearing no objection, they are adopted. Is there a motion on the bill as amended?
Move the bill as amended.
So moved. Is there a second?
Second.
All those in favor, please raise your hand. Is there anyone opposed? Please raise your hand. Okay, that is unanimous. Okay. The next bill is House Bill 454, Health, Occupations, Licenses, Certificates, and Registration, Immigrants. Council.
This bill, as originally introduced, prohibited a health occupations board from denying a license, certification, or registration to an immigrant if the individual meets the relevant educational, training, or professional requirements for the profession, and authorizes the use of an individual taxpayer identification number for licensing purposes, and makes other related changes. I circulated yesterday a reprint of the bill with amendments from the sponsor to prohibit a health occupations board from requiring that an applicant provide proof that the applicant is legally present in the United States or have a social security number or individual taxpayer identification number as a condition for licensure, certification, or registration. Authorizing a board to require applicants to disclose a number other than the social security number or TIN identifying the applicant, and provide an affidavit as authorized under federal law, and include identifier number information in a list that's provided to SDAT. This morning, I circulated a track changes version of that reprint from yesterday with some changes suggested by Robin Elliott, who's on this call, and the sponsor of the bill, Delic Lopez, who's not on the subcommittee, but is the sponsor of the bill, is also here now to discuss that. The changes essentially take out that alternate number option because, and Robin's here to explain it, but of concerns that that might not actually be a viable option, and that it might end up actually hindering some of the board's activities.
So the printed version in front of us, these are the amendments that one can assume will be offered to the bill or are being offered to the bill. Is that correct? Okay. Is everyone clear on that?
Delegate Lopez is here, so she can speak to
okay.
her intent to offer the amendments on the bill.
Sure. Yeah, these
Delegate Lopez, you are recognized.
thank you. Sorry about that.
That's okay.
Yes,
okay.
these are all sponsored amendment. The spirit of these amendments come from having to make our language compliant with the federal rules. There's all sorts of federal provisions that have to be included. And so So this subcommittee should know that some of these provisions about compliance are taken from what they're doing in Arkansas. And so we've taken the language that's working to make it drive in Arkansas and using it in our draft amendments here.
That raises, when you mention Arkansas, how many other states have adopted a similar practice?
There are, if my memory serves me correctly, of the 58 states and US territories, I think 26 of them have some type of waiver along the lines of what we're creating. And some of them, you know, they have different ways of doing it, but essentially they all have social security number waivers. And the state that we reference most frequently is Florida. Florida and Texas are the ones that have kind of the leaders of this innovation.
So this bill is most similar to Florida and Texas, or is there a better, more accurate term? How would you compare this bill to?
Florida actually has a couple more steps involved, but they have the more lenient rules for waivers. And so you should know, I think the committee heard testimony to this effect too, that many times people who might want to come to Maryland to be licensed as in healthcare occupations first have to come to Texas and Florida and work for a few months or an indeterminate time while they wait for their licensing paperwork to be completed in Maryland. And so that's what we're trying to avoid. We don't want you to have to go to Florida or Texas and spend 6 months working there. When, if you want to come to work in Maryland, we have a shortage and we want you. So let's expedite our bureaucratic red tape so you can come and enter the workforce and serve our constituencies more quickly. And Robin Elliott and Michael Patty, feel free to jump in if my data needs some tweaking, but.
Are you saying that under existing law, dealing with other licensing circumstances, having nothing to do with the issue here, people have to go to Texas or Florida, or?
Yes.
Go ahead, please explain.
Yeah. So once there's if you're coming to the United States as a healthcare worker on a work permit, there's a process that has lots of different levels to it, right? But essentially you need to be trained, right? And able to be employed based on that training. And then there's a process where there's a labor market assessment that's done. If you are a nurse or a physical therapist, that process is waived and you don't have to go through Department of Commerce, you just go through USCIS. But there's a process where you also, in addition to all the immigration services, you're also trying to get your licensing. If you're going to a state like Texas and Florida, those processes can occur at the same time. But if you're going to Maryland, you have to be in the United States and be here for a certain amount of time where you be working and paying taxes so you can apply for the I-10 so that you can apply for your license in Maryland. So what we're trying to do is to be on have the same type of scheme as the other states. So that way you can apply for your work permit and lawful reason to be working in the United States along the time you can be applying for your healthcare occupational licensing. So this process can occur simultaneously.
Okay, under this bill. That would be the case under this bill.
Yes, that is the intent of this bill, is so we can have these things occurring simultaneously. So that way we don't have this backlog of people who would want to work in Maryland, but have to go for Florida, which we would not want to curse upon anyone.
I should allow members of the committee to raise their Delegate Bhandari, followed by Delegate Morgan.
Thank you, Mr. Chair. There is an AG letter as well that this bill is also consistent with the findings and recommendation in the 2021 annual report of the Skilled Immigrant Task Force. As the proponent of the bill said, that the half of other states have enacted laws providing the similar one. Thank you.
Thank you. Delegate Morgan.
Thank you. Thank you, Mr. Chairman. How would this affect it as far as like H-1B visa holders that are here for?
So there's many different types of visa holders who could be a part of this, right? So if you are a legal permanent resident or a green card holder, you will have a social security number, right? But anyone who's a permanent resident is going to have a social security number. But the issue with all of these processes, whether you are on an F1 or an M1 student visa, whether you are trying to do the I-140, whatever it might be, all of these things take time and are a process. Sometimes it can take 6 weeks, sometimes it can take 9 months. And so the long and short of it is that it's just an extensive process. And when you combine that with how long it takes to get your occupational licensing, it could be in some kinds almost a year. And so that's why we're losing out on one of the reasons why we're losing out on nurses. And so, people who have H-1B visas, I believe they would have enough of a permanent status to eventually be eligible to apply for a social security number. That's the important thing to know. Anyone who's going to be here permanently is going to have a social security number. You just don't get it right away. It's a process.
So let me try to articulate like some concerns and maybe you make me feel better about it because, honestly, this bill doesn't really bother me that much because it's dealing with the health occupation and we need those employees. But I guess one concern is what would stop like a temp agency or a large employer from bringing in, a group of, foreign nationals, maybe from India or some other country like that on a visa project. And then they would be able to get licensed very quickly and I guess start work at some of these hospitals and other places where they're needed. Could that occur?
It sounds like what you're describing is a lawful process that we kind of have in place, right? So there's, like you heard from Adventist, they understand that there is a labor market, mostly in the Philippines and South Korea, of nurses who are trained at the American standard for nursing, right? Like there are schools that are there that train people to come work in the United States. And so they reach out to those schools, but it's because of our onerous licensing process, they can't get licensed until they have an I-10, but you can't get an I-10 until you're here and working. So it's chicken or the egg, right? And so what you're describing is like if an employer, I guess, are you talking about like undocumented people?
No, I actually wasn't talking about undocumented. I was thinking like a situation where like you have a temp agency or sponsors that would almost set up for like a business and use these people as almost like independent contractors. I guess my concern is, are we putting in a process in place that removes some of those barriers that may end up displacing American workers?
Yeah.
That was my concern.
Sure. My understanding is that you can't have a work visa as an employer. You can't go through the process of applying for a work visa for an employee that's a 1099, because a 1099 person is not technically an employee, they're a contractor.
Right.
And so it's very different. If you're going to employ people, it's a more formalized standard in place. So you can't, I don't think there's a pathway for an employer to take someone from another country and apply them as a 1099. It's very
well. I don't want to get stuck on that because I said 1099. I'm just asking a question. I don't know, but I do know that was an issue with a lot of the tech firms, like over in the Virginia area, that you would have a lot of H-1B visa recipients come in, and they used to put almost like a list of the employees on the wall, and so you would know they had to disclose those. And it was just, I remember them working considerably cheaper in the long run than a lot of the tech workers over there. And I didn't want to set up a system that could possibly displace American workers. That was my concern. So,
Sure,
well, thank you for the answers.
sure.
Delegate Bandari.
Yeah, thank you. For the clarification, yes, H-1B visa holders is stated on the bill. They will have a social security number and they will be eligible under this provision.
It should be, I mean, I don't want to get too far in the weeds, but H-1B visa holders are people who usually work in tech, right? It's considered the high skilled visa. So like, for example, tech companies
Yeah, I'm probably not.
and Meta are trying to get those folks over. Someone who would come over on an H-1B visa would not be likely interested in a healthcare occupational license. But
Yeah, I realize that. I'm probably using the wrong terminology. I know H-1B is for high tech. I know there's different provisions in there as far as nonprofits. I got to imagine there's some type of visa holder that we already have for healthcare workers. I can't imagine that we don't already have that. I just don't know the terminology. I'll look it up. Thank you.
sure, there's a certification form through USCIS called healthcare worker certification form, but they typically people come over on an I-140.
Okay. Delegate Bandari, do you still have your hand up?
Yeah, I would like to move this amendment.
Okay, there's a
Second.
move and seconded. Is there any further discussion among the members?
And just for clarification, this is the amendment circulated this morning with the track changes from Robin, just so everybody's on the same page.
As reflected in the reprint of the bill, correct?
Yes, so it was a
Thank you.
print of the bill and then there's track changes on that. And it was circulated via email this morning.
Okay. There being no objection to the amendment, it is adopted. Is there a motion on the bill as amended?
Move the bill.
So
Second.
moved and seconded. All those in favor of the bill as amended, please raise your hand. Is there anyone who is opposed to the bill as amended? Delegate Morgan.
Switch my vote up, but yeah,
So you are opposed.
right now I'm opposed.
Okay. So it's 7-1. Okay.
Mr. Chair,
Yes.
Delegate Riley had her hand up and I'm just not
Yes,
sure.
I'm
Oh,
sorry.
I apologize.
Yeah, my video, I only see one person and that's the person talking and I have no button, so I don't know where everybody is.
All right. So do you wish to be recorded in opposition?
Yes, I do.
Oh, okay.
I'm trying to fix it, but to get everybody back.
No problem. After last week, I can't give anybody a hard time about technical problems.
I might go
We're
out,
here.
come back in, start my computer over.
Okay,
Okay,
the
thanks.
bill moves forward. That was a very positive discussion. Next bill is House Bill 454. Oh, no, we just did that one. Sorry, I didn't move it. 507, State Board of Physicians, Graduate Registered Physicians Licensure. Council?
So this bill was discussed last week as it was originally introduced. The bill would have established a licensing and regulatory scheme for graduate registered physicians under the Board of Physicians. There were amendments circulated last week that were briefly discussed, striking the bill and instead authorizing a physician to delegate delegate duties.
Oh,
There
these
was
are for the people
updated-
who didn't get a residency?
Yes, so these
Okay.
are people who've graduated from medical school, but have not been matched with a residency program. So I've circulated updated amendments from the version from last week. So a new amendment, excuse me. The differences from last week are that you're still getting rid of the licensing scheme and instead authorizing a physician to delegate duties. But the new terminology used is a supervised medical graduate. Then the amendments also define direct supervision to mean personally treating the patient, and in the the delegating physician is personally treating the patient and in the presence of the patient and the supervised medical graduate. The amendments get rid of the requirements for facilities and employers to ensure that the requirements are met, and instead requires delegation in accordance with regulations that are adopted by the Board of Physicians. And I believe these amendments are supported by both MedChi and the Board of Physicians. I see Steve is here. I thought I saw him as well earlier. And then Delegate Lewis, I believe has joined us. I'm not sure. She spoke to me after these amendments were circulated, saying that she is also interested in adding a change to make the bill an emergency bill. She is concerned about like getting these folks available into the workforce quickly. So I don't know if she's here to speak to that.
First, Mr. Wise, can you speak to the amendments and their support by the affected parties?
Sure. On behalf of MedChi, we support the amendments that Ms. Rowe just described. And as to the addition of the emergency piece, we are fine either way on that. That may be more of a question for the board in terms of their ability to implement it quickly.
Mr. Dudzik?
Thank you. Yeah, we support the amendments as described. The one question we would have is if this is being adopted as emergency, because this requires us to establish regulations to handle this process. We would need to kind of look at the timeline for that, but we have no issue with the bill as amended.
Well, I know somebody who might be able to help you with the ALR process.
Well, I appreciate that, Delegate. I think that we
Certainly.
would probably be working very closely with you if this passes.
Oh, is there a cross file?
No, there's no cross file on this bill.
Okay.
And also just to clarify, the bill's effective date right now is October 1st. So if the subcommittee is not interested in making it an emergency bill, you could change that effective date to something earlier than October, but not as soon.
Well, certainly, if we do add the emergency language, there is time between now and sign a die for the board to share with us its thoughts on the viability of emergency status.
Absolutely.
Okay. So is there an amendment? Is there a motion on the bill as amended in the document before us? This is not speaking yet to the emergency language. Is there a motion on the bill, on the amendments?
Move the amendments, holding the emergency question for after.
Thank you. Thank you.
Second.
Seconded.
Second.
Hearing no, is there any objection? Okay, those amendments are adopted. Is there a motion on the emergency status?
Move to make the bill an emergency bill.
Is there a second? There is a second. Is there discussion? Seeing none, all those in favor say aye.
Aye.
Anyone opposed? Okay, the bill as amended with including as an emergency bill.
Move the bill as amended.
Moved as amended. Thank you, colleague. All those in favor say aye.
Aye.
Aye. Is there anyone opposed to the bill as amended, both sets of amendments? There is none. It is unanimous. Okay. The next bill is 531, Certified Nursing Assistants Licensing Requirements and Administrative Updates. Delegate Kerr, Council.
This bill repeals references to geriatric nursing assistant and replaces them with certified nursing assistant, essentially removing the bifurcation of those two designations. The bill alters the definition of CNA to specify that a CNA has successfully completed an approved nursing assistant training program. And that definition is altered to mean a course of training that meets the basic nursing assistant curriculum required under federal and state law. By October 1st, 2023, the Board of Nursing must notify individuals with a GNA credential of the bill's requirements, update as necessary a GNA credential to a CNA credential on renewal, update regulations to conform with the bill in consultation with the Office of Healthcare Quality, and notifies licensed nursing homes in the state that they're now permitted to employ board certified CNAs who successfully complete an approved nursing assistant training program without the designation of GNA to perform delegated tasks. There were some amendments offered in testimony from the Board of Nursing, and I know that the bill sponsor and advocates have been working with the Board of Nursing to work through amendments to the bill. And I see that Dana is here. I'm not sure if I saw anyone from the Board of Nursing here as well to discuss where you are with the bill, but I think that's sort of where things are at this point.
Okay. Dana?
Sure. Thank you very much, Lindsay. And we are still having discussions with the board. The intent of this bill was really to try to develop a process so we can level the playing field. So anyone who graduates from a nursing assistant training program can work in all settings. But what we don't want to have happen, especially with our workforce crisis, is to put additional requirements on those CNAs that might be working in other settings. So we're being very sensitive to that. So we're still trying to work out some issues regarding the substance of the current CNA programs and how they incorporate the federal regulations, which only apply to the nursing homes, as well as some of the training issues regarding the, not the training issues, the exam that has to be taken in order to work in the nursing home. So at this point, we are continuing those discussions with the board as well as the Department of Health. We're also trying to figure out really what we would need to do in legislation and what could be done as policy or interpretation and regulatory changes to get to where we will hope we can be in the next year or two.
So I know you're well aware of the crossover
Well aware.
effect. So we will put this bill on hold, and you'll keep us apprised of the status of your negotiations.
Absolutely. Thank
And
you.
obviously you'll share that with the other parties.
Correct.
Fine. I know you will. Thank you. Okay, our final bill is House Bill 693, State Board of Pharmacy Board Membership and Delegated Pharmacy Acts.
This bill adds a registered pharmacy technician member to the State Board of Pharmacy, specifies that a licensed pharmacist may delegate pharmacy acts to be performed at a remote location to a registered pharmacy technician or registered pharmacy intern, prohibits a registered pharmacy technician or pharmacy technician trainee from making decisions that require the professional judgment of a pharmacist, repeals the prohibition on a registered pharmacy technician administering influenza vaccines, and prohibits a pharmacy technician trainee from administering vaccinations. The bill also extends the termination date for the Board of Pharmacy by 10 years to July 1st, 2033, subject to evaluation and reestablishment provisions in the Maryland Program Evaluation Act. I circulated a reprint of the bill with amendments from the sponsor that make the bill an emergency bill. Specifies that a licensed pharmacist may only delegate the entry of certain data into databases or patient charts to be performed at a remote location and not other delegated pharmacy acts. Specifies that a delegated pharmacy act includes administration of an influenza vaccine only to an individual over the age of 18 years and prohibits a registered pharmacy technician from administering any vaccine to an individual under the age of 18 years.
Is there a motion on the amendments?
Move the amendment.
So moved and seconded. Is there any objection to the amendments? Hearing none, the amendments are adopted. Is there a motion on the bill as amended?
Move the bill as amended.
Thank you, Delegate Bagnall. No
Second.
objection. All those in favor, please say aye.
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 Anyone opposed? Okay. The bill as amended is adopted or moved favorably. We are done. We have full committee at 1 o'clock. And I thank and of course, we are all but certain to be meeting again prior to next Thursday, but you will get what counts as what's considered adequate notice in crossover week. So obviously the chair will make, I would assume it at the end of every day's hearing, she makes that known to everyone. So thank you all very much. Bye-bye. We are adjourned.